Good morning. Good morning. It's Friday. Welcome back. I am Misha Janice with Presume Legal. And we are here to watch this Donna Adelson motion in limine regarding Chris Corbitt and trying to exclude the state's summary evidence that the state proposing to be included. If you're here, say hello. Say hello. We're a little bit early here, but I wanted to make sure that I had everything set up. Hi, Gigi. Good morning. You're first in line here. Early bird gets the worm, huh? So, we haven't started here in court yet, but I just need to make sure that I have everything sort of set up and ready to go once they go live. I am connected to both a Zoom stream and the Law and Crime feed. So I'm just testing that out, making sure that we're going to be good to go. This looks okay. Good morning. Let me see. CWCTLH. Is there a pronunciation for that? Because I think maybe not. But hello from Tallahassee. How are things up there this morning? Man, you're going to be getting a lot of action up in Tallahassee very, very soon. Are you going to be stopping by the courthouse at all? Are you going to try and go to trial? What's the deal? Give us the details about what's going on in Tallahassee. Good morning, Lou. Thanks so much, Helen. Good to see you this morning. Hi, Linda. Good morning, friend. You too, Angela. Good morning. Top of the morning to you guys. Hi, Lori Woodman from Indiana. All right. We got a Hoosier in the house. Hi. Consultant channel hopping. Would love to be able to. I know. Yeah. You know, that's the thing. There's a lot of options, but I think that's a good thing. You know, there's a lot of creators doing their thing. So feel free to jump in, jump out. I'm so glad that you're here right here at this moment. You can, leave back if you want to, say, hey, let us know your thoughts. Always happy to see you. And thanks for always supporting the channel too. Appreciate that. Hi, Marcus. Always love you with the emojis. Yes, I see them. Good morning. Oh, what a great community this is. Good morning, Aunt Nancy. Good morning. Gigi's asking, do I have any thoughts on the Robert Adelson gag order? One, I don't think that there has been an order put in place yet. I did see that, and let me show this to you guys real quick, just in case you don't know what Gigi's talking about. Sorry, as I'm clicking away here. This is the docket for Donna's trial. And you'll see here this last entry as of, it must have been late last night, or at least after I logged off, that this was put on. This is there was an order made by Donna, and I believe it's concerning the testimony of Robert Adelson. We don't know what it is because the order has been made under seal. So we're not going to see the text of the order. We don't know what it says substantively, but we sure can speculate, can't we? So drop your comments below if you have any idea what this order could possibly be. Is it a mother trying to keep out the testimony of her son, Robert Adelson, for some reason? If you'll recall, Robert Adelson is the other brother. The oldest brother who left the family. All right, I think we're getting some action here in court. So let me share this with you. Okay. Kind of loud, right? Can you guys hear it? Give me a thumbs up if the audio is okay.
I already did. The victim's family asking to be on Zoom once again. I do not know the answer to that, Judge. I'm sorry. Let me confer. I think we should probably assume so. Let me confer. I see a tie labeled with Markel. Okay, then yes, Your Honor. Thank you. Do you have any idea who Misha Janice is? I do not.
That was me.
The only reason I'm asking is because in the last hearing, someone joined Zoom who's doing inappropriate things. So from here, Zoom is going to be limited. If I get wind of anyone else trying to do inappropriate things in the midst of the Zoom, ultimately it's just going to be, if you're here, you're here. You're not, you're not. I'll go ahead and allow parties to make their appearances for the record.
Georgia Kappelman for the state, Your Honor. Sir Calvin Dugan for the state.
Dan Markel on behalf of Mrs. Adelson, be present. Alex Morris on behalf of Mrs. Adelson.
Very well, let's go ahead and move with the one hearing that was scheduled for today. This is the defendant's motion in limine concerning the testimony of Sergeant Corbitt and the summary exhibit. Whoever's arguing the motion may proceed. You may.
What does he need to approach for?
Judge, I think we filed pretty detailed papers on this. So I'll quickly summarize, and then if you have any questions, I'm happy to answer anything that you have. I think it's really important to realize we're not asking that he not be allowed to testify. What we're asking for is two pieces at this hearing, and there'll probably be more during trial regarding actual pieces of his testimony. So that's the third piece. The first thing we're asking for is that he not be qualified as an expert. We don't believe, as set forth in our papers, that he's testifying to anything that meets the standard of Florida statute 90.956. And so we don't think he meets the qualifications of an expert in what he's testifying to.
You mean 90.702?
I'm sorry, 90. Correct. We don't think he meets those qualifications. We think he is a summary witness, not an expert witness, and we think his report illustrates that. The report itself has essentially 5 components. It has emails, which are a culmination of emails that the state has taken and put in a report. Text messages, neither of which emails or text messages is he an expert on. He's just compiling them, putting them in a report. Video surveillance photos, and then it has call record summaries, which we'll get into, but takes no expertise to do the call record summaries. Florida law is pretty clear on that, as well as cell site data, but it's very limited to cell site data, especially with regards to Mrs. Adelson, who's on trial here. There's some more detailed cell site data with regards to Mr. Garcia and Mr. Rivera, but even that wouldn't qualify as expert testimony. The cell site data as to Mrs. Adelson, there really is virtually none of it. So
one question before we continue on track of the expert testimony. As it relates to items that the state can properly admit, and I'm sure there, based on your pleading, there are aspects of the current PowerPoint that are disputed as being inadmissible. But for what can be properly admitted, are you also disputing that those cannot be used as a demonstrative during trial by the state in some way?
No, they can be. So, in other words, there's no dispute that they can use the report as a demonstrative. There's no dispute that for the admissible items, they can put in the admissible items. So I'll give you an example. Email between Wendy Adelson and Donna Adelson. Clearly it's admissible, provided it's relevant. The ones they provided are relevant. Clearly admissible. The underlying email can be admitted, shown to the jury through an appropriate witness, if they call Wendy Adelson, for instance. Okay, so that email is admissible. But the summary of the email in the exhibit, the summary of the 1 or 2 page email in this exhibit can be shown to the jury, but it doesn't qualify as expert testimony or a proper summary exhibit to be admitted. Does that make sense what I'm saying?
It does. The one thing I would question even concerning demonstrative, are you also saying the state cannot put the context around these various pieces of evidence?
No, they can, right? They can make arguments just like they do in closing arguments, right? They can show the exhibit to Corbitt, Sergeant Corbitt. He can put it on the screen. He can explain whatever he's going to testify to. Our argument is he's not an expert in doing that. That's our first argument, and our second argument is ultimately that 329 pages right now doesn't go back to the jury. It's a closing argument, essentially. When you look at his 329 page exhibit, and again, I'm getting a little ahead of myself, but when you look at his 329 page exhibit, it's essentially Ms. Kappelman's closing, okay, which we don't admit to the jury. The jury doesn't get her slides and see them in the jury room deliberating. But no, of course, they're able to, provided it's admissible material in it, they're allowed to show the exhibit. They're allowed to use it as a demonstrative. They're allowed to question Sergeant Corbitt. He is allowed to be a witness based on what he did. Our argument is, number one, he's not an expert, and number two, the actual exhibit is not an appropriate summary exhibit that would go back to the jury during deliberations. That's what our memo is about. And it's supported, Judge, by Florida law. So the Florida Supreme Court has held that law enforcement testimony, which merely summarizes and explains data from cell detail records, including the mapping of cell phone location data, is not expert opinion under Florida Statute 90.702 and Daubert, because it involves no scientific, technical, or other specialized skill. Cites King v. State 260 SO 3D 985, Florida 2018. McMillan v. State 214 SO 3D 1274, Florida 217. The Florida Supreme Court has supported that, and also has the 11th Circuit in Batista, B-A-T-I-S-T-A, in affirming the Florida Supreme Court, where the 11th Circuit of Court of Appeals affirmed the district court's decision to admit as lay testimony an FBI agent's use of cell phone records, along with the phone company's records of where their cell phone towers were located, to plot on a map which towers connected with which cell phones at a particular point in time. But it said it wasn't expert opinion. It said that you don't need the agent doesn't have any expertise to read the cell phone records to determine which cell tower was used at a particular time, look up the latitude and longitude of that cell tower in the company's records, and mark the intersection of the latitude and longitude on a map. That's precisely what Sergeant Corbitt is doing here. It is exactly on point to what he's doing here. Also, the fact that he pulled data off of iClouds and he pulled data off of iPhones, it's not expert. Now, of course, he's able to testify to it, but it doesn't meet the standards of expert testimony. Now, moving to the second point, Judge, which is whether...
Before you move on to that, when it comes to the data pulls, because I've heard this argued, not by you, but a number of ways over the years. The first being the data pull itself is a factual issue, which I would agree. How the machine works and whether or not the data pull was in fact, it took place technically in a correct manner, that goes to more specialized information. Is there going to be any contesting of any way that the data pull was somehow not technically proper or sufficient? Because if so, at that point, now we are veering into a matter that deals with specialized information, knowledge, or expertise.
Judge, may I have one moment, please?
Go ahead.
Huh. Brash is like, what do I say?
Stipulated to that. That's one of the things you stipulated to. All right. So
George is saying
figure that out. Okay.
they stipulated to that already.
Judge, I don't believe it's going to be an issue.
Believe.
But we understand what you're talking about. If it were to become an issue, then obviously the expertise on that particular issue would be obviously subject to his qualifications, which we think he has. Okay, but at this point, we don't anticipate it being an issue. We don't anticipate. There may be questions as to why he pulled it as opposed to someone else pulling it. But as far as whether it was pulled appropriately or not, we're not contesting that.
Very well. You may continue.
Okay, so Judge, if I may just move on to the second part of the argument. The second part of the argument is not dependent on the first. So whether he's an expert or not an expert, it really is an independent inquiry, the second part of the argument, which is whether ultimately whatever turns into his exhibit, his demonstrative, goes back to the jury. And again, for purposes of today, unless you want to go into it, I'm not going to be talking about specific pages that we don't believe are admissible. So let's just talk about the thing as a whole, if that's okay with the court. So, Judge, this summary, and I think you've had an opportunity to view it. It's not, the first thing to understand is it's not a neutral summary. That's the first thing to understand. The second thing not that alone does not end the inquiry. It's just a fact.
Well, to that, and obviously a criminal case is different from a civil case, but all the time, in civilly litigated matters, parties will have presentations, reports, summaries prepared. The plaintiff, by nature, is adverse to the defendant. Anything that they're preparing for the jurors is going to advocate or in some way demonstrate why I should win. As it relates to this summary, the state is prepared this in anticipation of litigation to advocate their position. Why is this inappropriate?
That alone, that fact that it's not neutral, is not the determining factor.
Answer his question.
It's one that courts would tell you to look at in deciding whether it is a summary that's appropriate to go back to the jury or whether it is more in line with a closing argument, which would not be appropriate to go back to the jury. So I start with that just because it's just as a basic factual point. I don't think it's determinative of your decision. What is determinative of your decision, though, is when you look at this summary, it's full of items. Again, we're not disputing that the items are admissible. Let me be clear on that. So the summary has, for instance, I think at last count, 30 to 40 emails. Those 30 to 40 emails, provided they survive evidentiary challenges, are admissible. But a summary is done for the purpose of taking voluminous records and synthesizing them in a way that helps the jury. That's what the statute talks about, right? And that's what the case law talks about. That's what Oloyede talks about, which is 933 F3rd 302 310 4th Circuit 2019, where it talks about how we don't send closing arguments back to the jury. Right? That is not admissible under law, because summaries are elevated under Rule 1006 and also Florida Statute 90.956 to the position of evidence, care must be taken to omit argumentative matter in their preparation, lest the jury believe that such matter is itself evidence of the assertion it makes. So in this document, you see a bunch of items that are not voluminous. They're one page. Rental car agreements. There's no summary needed for that. 2-page emails, 1-page emails. There's no long emails. 1-page text messages. Not necessary. And then you see call records, and you see some call summaries. Again, not voluminous materials. I wish they were, but they were limited in what the call materials were. So, Judge, our argument is that the exhibit itself can be shown. We're not arguing that it can't be shown to the jury.
As a demonstrative, but not as admitted evidence.
Admitted evidence. The underlying evidence in it that's admissible can be admitted, obviously. Now, within the summary, and I think this may be better taken up at trial or in another day, unless you want to take it up now, within the exhibit, we
Hold on. As to any pages that are specifically disputed as inadmissible, it's best to handle this outside of the presence of the jury, so that way it's clear what is in and what is out when all of it is ruled on.
Yeah, so I mean, we can do that at your convenience. Look, the state has still been updating it, so things may change, but we already see some pages that are either hearsay or privileged under the joint defense privilege, for instance. We already see, there's not a lot, but we already see some pages that we think are problematic, and we can take that up whenever you want. But our argument today summarizes on his characterization as an expert, and either way on the document actually going back to the jury.
Let's handle that part of it then next Thursday if there are still disputes as to individual pages, so that way it can be handled and ruled upon.
Okay, thank you, Your Honor. If you don't have any questions, we'll rest on our papers.
Very well. State, you may respond.
Morning, Judge.
Good morning.
Sarah Dugan.
So the defense motion argues that, you don't have to be an expert in order to testify to phone evidence. And they cited the King and Gordon cases in their motion and talked about it this morning. I think it's important to consider that in both of those cases, which were post-conviction motions, where the court said that the defense was actually not ineffective for not getting their own expert or not objecting to the witness testifying for not being an expert. The defense did not object to a non-expert law enforcement officer testifying to the cell phone evidence in that case because it was a strategic decision. The defense knew that they could cross the law enforcement officer more effectively than an expert, and the state could easily get someone more qualified had the defense objected. In Gordon, the court said that the witness from the phone company who testified would have qualified as an expert to testify to that data and been able to testify to the cell site data had there been an objection. In King, in that post-conviction evidentiary hearing, the defense put an expert on the stand who provided expert testimony on GPS and on cell phone location data. The defense expert concluded that the defendant could have been at home, not at the crime scene at the time of the murder. So in that case, there was an expert who testified to the location information from the cell phone records.
That does lead me to my first question concerning Sergeant Corbitt. What exactly is he going to testify to beyond what the cell phone data history records or cell phone tower records would show? That or otherwise you need him to testify through an opinion that he cannot just testify off the records themselves.
Yes, sir. So he's going to be, and I have this in just a second, but as far as the summary goes, he's not testifying as an expert to everything in the summary, but he's testifying as an expert to a large part of the summary when it comes to cell site location data and how far, who's using a handset at the time and how far the person is from the cell site location. He uses the more...
So you're saying how to interpret that data?
Yes, sir. And he uses more than just cell phone records to do that. But the cases, the Gordon and the King cases, those cases say a witness does not have to be an expert to testify to some of that information. But they're not saying that you cannot present an expert to offer an opinion on a handset's location. If that witness has the necessary training and experience, just as was done at the hearing in the King case and could have been done at the trial of the Gordon case. And Sergeant Corbitt has hundreds of hours of training and experience and has offered an expert opinion well over 100 times in circuit court. The reason they don't want him to be able to declare an expert, they don't want him to be able to offer an opinion. And this is more than just a data pull of, hey, we got these cell phone records, and this is more than just, this is where the cell site locations are at any given place in Florida. This is him forming an opinion on how far a handset is from a location, who may be using the handset at the time that you need this specialized, or that it's beneficial for the jury to hear his specialized knowledge because he's able to interpret the cell phone records to tell us that information. The defense also argues in their motion that there's basically just too much evidence in this summary, that it's more than just for phone records and some of the evidence isn't voluminous. But a summary's whole purpose is to summarize relevant evidence. Sergeant Corbitt, as I said, is not offering an expert opinion on everything in the summary. He's offering an expert opinion on the interpretation of the cell phone records, the location of the handsets, who may be using the handset at the time. And there's a large part of the presentation that are those things, but there's a lot more information in the summary, like surveillance video from Premier Gym, a traffic ticket received by the suspect, a car rental agreement, that maybe those things individually aren't voluminous, but they're all material to the presentation and material to his opinions because he's using them to provide an opinion on who had the handset and where the handset was at the time. For example, if a certain suspect's phone is communicating with a cell site that's consistent with like a car rental company, an expert may be able to better determine who was using the handset at the time and confirm their actual location and confirm the reliability of the cell site information. If we're able to see that, well, that person actually got a rental agreement at the time, they got a traffic ticket shortly after the car was rented, all of those things help him form his opinions and determine that. The defense says, this is a closing argument. The information that he looked at in this case, there is so much digital evidence that it is very all-encompassing. However, there's not, what's in the presentation is not, it's all data. It's messages, it's emails, it's different business records and cell phone records that we received that helped inform those opinions. They talked about the 30 or 40 emails. When I'm handing them over the things that I may use in my presentation, I'm trying to be as thorough as possible. I don't want them to have less information than I may use. I don't intend to use all 30 or 40 emails. I don't intend to have Sergeant Corbitt sit up there and read all of those, but I wanted to send them all of the ones that I may use as far as just, these are what was found in these different accounts. This was and asking him, hey, did law enforcement find some evidence of motive that caused him to look into these people? Yes, X, Y, and Z were found. Maybe spend 3 minutes to 5 minutes on that and move on to the next thing.
As to that point, and I believe the defense's motion hits on this as well, for what you have asked Sergeant Corbitt to add to this, is that in fact his opinion?
So the defense motion attacks that, the prosecutor is ultimately deciding what's going into the presentation. Maybe that's what you're referring to.
Yes.
But Sergeant Corbitt's job is to pull information from these devices, interpret that data from the cell phone records. He's not investigating or prosecuting the case. In the investigative phase, he has to rely on the investigator to let him know what he's looking for, what this proverbial needle in the haystack is, whether he's wondering it exists. And Sergeant Corbitt's been looking through the records to see if there is one, and then if there is one, including it and letting them know. Sergeant Corbitt doesn't know exactly what the prosecution wants to present at trial. I talked to him about what the records show. I asked questions. He looks for answers. He lets me know what the data says. And then I'll say, yeah, can you put that in there? I think that that's important. He's not the one talking to witnesses. I may talk to a witness. They tell me a certain event occurred. Then I go back to Sergeant Corbitt and say, hey, is there any evidence of X happening? And he lets me know that. That may corroborate what the witness says, and then we're able to put it in there. And I'm not able to get that information in any other way because he's the person that's looking in these cell phone records and can let us know whether that evidence is corroborated or not, and can provide an opinion on whether what the data shows, where that handset was at the time, where that, how far they were from the tower at the time, things that may corroborate witness testimony or appear in the cell phone records that I wouldn't be able to see or know on my own. The defense motion also argues that the summary isn't admissible, but summaries are admissible. That's the whole point in using them, and there's no case law that I know of that says otherwise, that a summary isn't admissible and has to only be used as a demonstrative, and the defense doesn't cite any either. The defense has specific objections to certain slides because of hearsay or privilege or other things, which I'm ready to discuss at any time the court is. But as far as the summary not being admissible, there's no case law that I know of as to that, and the defense hasn't cited any either. That's all I have.
Very well. One question about the document itself. And I think this is really what goes to the heart of the defense's motion about the summary. If you're taking, say, thousands of pages of documents and you reduce them to, let's give it an arbitrary number, a 25-page report, you have synthesized the larger to the smaller into something that is digestible for the jury to use in making their decision. That, or at least according to their position, is not argumentative. Some of these things are more or less a part of the state's summary, at least as it stands right now. It's showing corroboration of other evidence. Is that in fact a summary in the sense that the statute defines a summary?
Yes, sir. I mean, this is the things that may corroborate other evidence, though, help this expert form his opinion. As the example I gave with the traffic ticket and the rental agreement, he's able to, from the phone records, say this phone is consistent with this cell site at the time. They may be this far from there, but as far as showing who has the handset at the time, like who's talking on it, and how far they are from it, it's all of those other evidence that helps him form his opinion.
Very well, thank you. Brief response, if you have one.
Really brief, Your Honor, and I just want to make this clear, and I think you understand our position perfectly. We're not arguing that summaries are not admissible. We're arguing that this isn't the proper summary.
Where's Donna?
That's the argument. We don't make an argument in our papers that summaries are not admissible. We're saying that this document doesn't meet the foundations of the Florida statute as a proper summary. Again, they're taking particular points, but these are not voluminous documents that they're now summarizing. So there's only one voluminous document that they're summarizing in this entire presentation, and that's how they got originally to Harvey Adelson's phone number, where they had data that would go to the ceiling. If they wanted to do a summary exhibit on that piece, it might be allowed. But everything else is not voluminous materials. It's a closing argument. To allow them to put that document to the jury would essentially be the same as saying, you know what, Ms. Kappelman, Ms. Dugan, when you do your closing, the PowerPoint that you do, that should go back to the jury too. Because it's essentially the same thing, Your Honor. There's no difference. That's all I have, Your Honor.
All right, concerning this motion, I'm prepared to rule on part of it today. As to whether or not Sergeant Corbitt can be properly qualified as an expert witness, I will find if Sergeant Corbitt is capable of testifying to the interpretation of the records that go beyond just merely where the towers are, what was pinging, and what the phone records show, that would go to scientific or technical expertise in which he is properly able to give an opinion. As to the summary itself, and I do not want to belabor this point, but I do believe I am going to need to hear from Sergeant Corbitt specifically as to how he put this together, and his opinion was informed by the information that is in the summary before I can rule on it. Otherwise, I agree with the defense position. This is proper as a demonstrative, but to admit it as evidence, I'm going to need to hear more. We'll have part 2 then, in which Sergeant Corbitt can testify concerning how the summary was created and how his opinions were formed by the evidence that are within the summary after we have the docket sounding next week. As to another matter in which I am prepared to rule on at this point, concerning the defendant's motion in limine, concerning testimony from Wendy Adelson as to the storyline of her book and also changing the names of the children, I will permit the state to use this information for impeachment, depending on what is developed during the examination of Ms. Adelson. As to the other matters concerning her testimony, that has already been ruled upon. Has the state also decided which jailhouse recordings you are intending to use for evidence? Because I did need to review those.
Yes, sir. As of right now, we do not have any jailhouse recordings that we intend to introduce that feature Mr. Adelson, which is what the defense is objecting to. So that's why we have not sent any.
Really?
Can I clarify what you just said about the name changes?
Go ahead.
You said it could be used for impeachment. May I? She admits that point, or has previously. Would I be permitted to inquire about that area?
As it relates to any prior testimony she's given on the subject, you may inquire as to that. Very well. I believe still outstanding.
Judge, sorry.
Go ahead.
I just want to make sure I understand now. So our motion was to prevent them from inquiring as to the name changes. So in other words, our motion was Ms. Kappelman or Ms. Tugin can't ask her the question, did you change the kids' names? That was what our motion was. So I'm not sure I'm just not sure the ruling. Can they ask that question?
Well, on that particular point, what is this being offered for, Ms. Kappelman?
A motive, Judge.
Mm-hmm.
As it goes to motive, I will permit it for that reason, or also impeachment, depending on what comes out. Motive and bias are equally available for both parties to explore. All right. As to the state's motion in limine, I believe there is also one other outstanding item to be addressed concerning Luis Rivera's gang affiliation. As to this particular point, and I've researched this further, Mr. Rauschbaum, as to the name of the organization, I'm really failing to gather why hearing I was threatened by a gang member versus I was threatened by a Latin King member is going to in some way create a greater credibility in front of the jury for the narrative that you wish to weave. I will permit Ms. Adelson, if she testifies, that she acted in accordance with being threatened by a gang member. The specific name of the gang, I don't believe in any way is going to assist the trier of fact in terms of assessing her story, whether it's credible or not. They will make their determination if they believe this testimony. I believe that was the only other outstanding matter of the state's motion in limine. As to Jeff Lacoste, I have not finished my research yet on that matter, but I will rule on it before we start with any selection of the jury. Do the parties have any other matters that we need to address this morning?
Yes, sir. Just a second. Judge, in contemplation, like a planning when to start evidence, can we all agree that we would not start the presentation of witnesses until Friday, the first Friday.
Assuming that we have the jury selected by Thursday.
Yes, sir.
Well, that would probably be appropriate. Does the defense have a position concerning this?
You have 1 moment.
Go ahead.
That's fine, Your Honor.
Very well. Assuming we have a jury by Thursday afternoon, we would start with the case on Friday. Well, would the parties be able to go to their openings, assuming there's enough time Thursday afternoon?
Yes.
Mr. Rushbaum? Very well. If we have enough time then, after we have the jury selected and sworn, we would give openings and then launch into the testimony from there with all the witnesses. Does the state have an idea, at least in terms of days, how long you think the case in chief will last?
I think 6 to 7 for our case in chief, Judge.
All right. Does the defense have any idea at this point?
I would say, depends, obviously, but I would think 2 days.
Very well. No one's going to be held fast and firm to this. I'm just asking for an estimate. One other matter to address with the defendant directly before we finish this morning. Ms. Adelson, next week we are going to have your final pretrial. That is typically the hearing in which I inquire of both parties if they are in fact ready to go to trial, if any continuances are necessary, and also information concerning plea offers. As I stated to you at a previous hearing, I do not prod people to take pleas. However, if you wish to consider a plea offer from the state, the time is rapidly coming for you to make that decision as to whether you desire to entertain any plea offer or not. If you want your counsel to provide an offer to the state, also the time is coming very close to a conclusion for them to do that as well. I'm not going to prod you either way, but I want you to be mindful of the fact, once we begin jury selection and the denial is sworn, that means trial has started. From there, basically because of count 1, if you are convicted as charged, my hands will be tied concerning any sentencing on that matter. Your attorneys will have further discussion with you concerning this, but if you are considering anything at all, you need to make a decision on this quickly. Do you understand where I'm coming from? Very well. We are in recess. I will see everyone next week at 9 o'clock, September 12th.
Judge,
Yes, sir.
maybe we briefly go sidebar.
Yes.
All right. Oh, what's going on with the cameraman? That's right. Donna's not looking so well, in my opinion. She does seem alert. She's looking for notes from her counsel. I think that was a quick sidebar.
That is the conclusion of the hearing for today. Have a good Friday, everyone. We're in recess.
All right. Let's see if we can get another look. Oh, they cut it off already. Yep. Yep, they cut it off. All right. So let's get into this a little bit. Let me go back and read some of these comments back to the beginning. So that took about half an hour, I would say. We haven't gotten to the puzzle pieces yet, Lou, but don't be surprised if you hear them. If you hear them in opening statements. I don't know if he's creative enough to have thought of a, different analogy yet. Incredibly lucky you didn't. Oh, I wanted to go back and look at this comment. CWCTLH says, I was actually making arrangements to volunteer in Wendy's legal clinic right before the murder happened. Now, this viewer is in Tallahassee, right? So possibly a law student, maybe, or a med student. I think it was a legal medical joint sort of clinic. So, wow, that is that's quite something, huh? Can you imagine the stories that you might have told if you were actually able to work alongside her or under her direction? Yeah, apologies, you guys. The audio quality was not great, but there's nothing that I could do about that. But thank you for being here. Anyway, I really appreciate all you guys showing up, showing out. Love the comments. Love the comments. Thank you, Kel. Thank you for being here. No problem. It's my pleasure to share this. I was really curious after reading through the defense motion yesterday. Good morning, Judy. Good morning, Crazy Joe Lowe. Marcus says, Rashbaum doesn't sound so animated today. I mean, he probably has his tail between his legs a little bit. Between the hearing last week and the orders that have come out since then, their client hasn't been faring so well with their motions. Welcome, Linda Faye. Welcome to the channel. Welcome to the channel. Welcome to the craziness. We are over here. Hey, Mona. Rashbaum can testify as an expert loser. Oh, my goodness. Isn't that the truth? She, I think this is talking about Wendy, superficially seems so sincere. I sarcastically refer to her as Ms. Sweetness and Light. Sweet and light? Sweet and low? Very funny. All right. Annabelle Warmington, good evening to you in Australia. Thanks for covering this, Nisha. I'm totally fascinated with every aspect of this case, as all are we, Annabelle. We just can't seem to quite get enough of this case. And there's so much going on with the case, right? And I think that's partially why it's so fascinating, just because there are so many moving parts, so many nuances and branches off the tree of this entire saga. Justice for Dan Markel. Absolutely. Yeah, we saw Donna present. They showed her quickly at the very beginning of the hearing, and then the hearing got started really quickly. So the cameraman panned to the judge. Good morning, New York Patriot Lady. Good morning. She's here. Good morning to y'all. Justice for Dan Markel. Absolutely. Happy Friday. Happy Friday, you guys. Linda Faye is over here singing a Harvey song. I wish you could call in so that you could sing this song. Harvey's song. I had a girl, Donna was her name. Since she left me, nothing feels the same. Oh, I love that girl, Donna. Where can you be? Where can you be? Oh, Donna, oh, Donna. Donna is sitting at the defense table. Look at her. She's not the Donna of last year this time, that's for sure. So we will yet to see if Harvey is going to show up for his girl. Will Harvey show up to trial? That's a great question. Wouldn't it be a shame if he didn't, or if he was so afraid that he felt that he couldn't show up for his wife, his one and only? Terrible. We'll see. Kel's wondering, I wonder if she took her Xanax. I don't know. There's some people out there who can tell really easily if somebody is impaired, I wouldn't say I'm necessarily one of those people unless, somebody is obviously impaired, like a tweaker. You've seen those tweaker videos where they can't stop moving. But other times, people who are impaired just kind of, they look almost normal. But those who know. So I don't know if any of you in here has any experience with identifying, people who take those relaxants like Xanax. Speak up. Let us know. Let us know. Young Black Economist says, "Hi, chat. Rashi looks better today than he did at the last hearing." Did he? He watched himself on TV and got embarrassed. That suit fits better. Not gonna lie. I mean, he looked like Rashi. He still didn't have his step stool or anything, but he was doing okay at the podium. I don't think the microphone was too high for him. And I don't think we got any like real close up frames of his face like we did in the last hearing. The last hearing, they just zoomed in, I think, a little bit too much on that baby smooth skin that he shaved. I'm not sure I like that look, but maybe, I don't know, whatever floats his boat, I suppose. I think he probably looks better with a little bit of facial hair, in my opinion. Yes, New York Patriot Lady. I did mention in my video that I posted yesterday reviewing the motion documents that defense did not oppose Chris Corbitt as an expert witness during Charles Adelson's trial. And I actually showed the clips of him not objecting when Judge Everett asked if there were any objections, if he wanted to voir dire Chris Corbitt. Rash was like, no, he's good. So yeah, very different from what he's doing in Donna's case. What is this? What does this mean? Let me go to the adult lawyer. Oh, I think that's when Rashbaum turned around to speak with his co-counsel, right? You guys are rough, man. Rash is too short to use the word expertise. Oh my goodness. Oh, watching on cell phone, Rash's bottom lip and chin moves like lips. Oh man. New York Patriot Lady, you've got to come back here to watch the trial with me because these comments, oh my gosh. Oh my word. Wow. Young Black Economist is asking, I don't understand why that guy isn't qualifying as an expert. He's not educated enough. Why don't the prosecution just use someone else? Well, Judge Everett said that he is able to testify as an expert witness due to his specialized knowledge regarding data pulls, how data pulls are done. He says that's a technical issue, and he does have technical specialized knowledge. So he will be able to testify as an expert witness. So in that sense, Donna's motion was denied yet again. Another denial. Rash wants more Adelson pot of stapled, laundered pot of dollars, easy money. I mean, if it's green, then he'll take it. Oops. Jody Landley is saying, problematic. Donna's guilty as heck. Yeah, I mean, it's a good thing that we're not in the jury pool, right? Because we've kind of already formed our opinion. We know the facts. We've seen all the facts. And this new set of facts that has come in that we will hopefully see in this, in the next coming 2 weeks is only going to bolster, I believe, what we've already seen. That, these defendants are guilty. Guilty. That's right, Aunt Nancy. Your Honor, please Please don't allow this evidence in. It's incriminating to my client. I agree. I like the color of Sarah Dugan's jacket as well. Very pretty color. Who thinks Wendy is watching this? Well, I mean, she's probably not watching my channel, but I wouldn't be surprised if she was, in fact, watching the hearing. And Lori agrees. Of course she is, she says. Scariella, Wendy is absolutely watching. Hi, crazy eyes. So Jody is asking, can I explain what Corbitt material exactly defense is attempting to keep out? Is it the outside your house text? I don't know exactly what documents he is trying to keep out. They didn't get into that. And Judge Everett said, I believe he said that next Thursday is going to be a hearing on the specific documents that the defense thinks are inadmissible. So we have yet to see. Right? What's going to be allowed in and what's going to be disallowed. I was too. And Nancy says, I'm surprised the state hasn't considered those recordings. Georgia said that. Georgia said that at this point, she wasn't considering entering in any wiretaps that include Charlie Adelson. So I'm a little surprised to hear that. Granted, there are a lot of recordings out there, right? But the one that I'm specifically thinking of is the hot mic one, where Charlie was on the phone, but the phone call dropped and Donna kept talking. She was speaking with Harvey. She was speaking with a friend in the background. And that's where we get her lamentations about how Wendy's treating her badly. And she's so tired. She's so tired. She just kind of wants to give up. This was after Charlie's conviction, obviously. And then she gets into talk about the passport and saying in anticipation of asking Wendy to, hey, can you come over and help us, fix our papers, get our papers together? We want to ask her about visas and extradition and stuff like that. But but Donna was saying she wants to ask her to help get their business affairs together. So I don't know. I'm kind of surprised, but we'll see how that's handled. We'll see how that's handled. Georgia knows what she's doing. So looks at Georgia. I missed that. Remember all the things that Donna and Charlie said about her. Yeah. In those wiretaps, right? Mary James says, I want to see a trial. What's the chances she'll take a plea deal? Boy, I don't really know. What are the chances she'd take a plea deal? I don't know that one has been offered to her. I feel like we would have heard about if she was offered something. But like Judge said, they can propose something to the state as well. So I don't know. Is she so delusional as to not want to take any responsibility at all? Donna, do you think your chances are still so good that you can just beat the charge? I don't know. I don't see it happening. But I do want to see a trial as well. We'd be a little disappointed, right? We would totally be disappointed if this didn't go to trial and we didn't get to watch it. Good morning, Riverdale Pilates. Good morning. Welcome. I'm glad to see you here. Scariella says, maybe an Alford plea. She doesn't have to admit guilt and can avoid a trial. I don't know. I mean, these people seem to have been so like above it all. Like we did nothing wrong. Even looking at the evidence in front of me, nobody in their right mind could say that I'm guilty. I mean, isn't that what they were saying it after Charlie's trial? If that's the case, and if she's still of the same mindset, then there's no way that it would be an Alford plea. I don't know. CWCTLH says, I was a Medicaid fraud investigator, but was also in paralegal school. Okay, all right. I was still working on conflict clearance for my employer when the murder happened. All right, so if you missed it before, CWCTLH almost was this close to working with Wendy in Wendy's clinic in Tallahassee. But, before she got started, or he or she, I'm not sure, the murder happened. And as we know, Wendy jumped down. She was not going back to Tallahassee. More talk about the plea. Linda Faye. I do, yeah. Now that you mention it, Richie Valens did the song "Oh Donna." Oh Donna, da, 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 da. Is that the one? Or am I putting a different melody to it? I don't know. Well, I'll have to check out Fancy Fiction's posts to see if she uses it. I don't know, between her and the Society page, who had a little 1-year birthday party yesterday, I'm sure that song has been played at least once in one of these videos, right? Yeah. Lou's saying, Wendy is watching. We know she can't help herself. All right. Bye, Aunt Nancy. Have a wonderful day, everyone. Top Cat, hey, you're here. Did the judge let in Wendy's book and changing the boy's name? So, yeah, one thing I wasn't expecting, the judge went back to some of the issues that were still pending from last week's hearing. And the judge said that the state can use Wendy's book, and the fact that Wendy changed her son's names as impeachment, and the fact that she changed the names can be used for motive, to show motive. So that's another motion denied for the defense, basically. The defense does not want that in at all. But the judge said it can come in. We'll have to see the circumstances that it comes in. But yeah, it could come in. Hey, Mona says the best part of this hearing was Judge Everett talking about accepting a plea. Time is of the essence. It sure is. Okay, so to wrap up the last little bits of housekeeping, we heard if the jury is picked by Thursday, then trial, testimony, opening statements will begin on Friday morning. So that moves the schedule up just a little bit. We still have to see how jury selection is going to go, but we could be starting openings as early as Friday morning. So keep that in mind. The state anticipates its case in chief being 6 to 7 days long, and the defense said they would only be taking 2 days. Of course, as always, the defense doesn't have a burden. It is still the state's burden to prove the guilt of Donna Adelson. So the defense doesn't really have to put on a case at all. And I anticipate that at the end of the state's case in chief, the defense will get up and say, the state hasn't met its burden. Judge, rule in our favor, dismiss this entirely. And the judge will say, no, denied. But that's just how it goes. That's just kind of like, I don't know. That's the dance. That's the dance of a trial. So that is it. I think that's it. We have to see timing of next week's hearing, next Thursday, Judge Everett mentioned that they would be going through the summary that the state wants entered. The defense doesn't want certain documents to be included because they say that it's admissible, either hearsay or relevance or, you know, any other grounds of being inadmissible. So the judge wants to see that and rule on those individual pieces of documentation. So I will check the docket and see what time that is and hopefully be able to stream that. All right, I'm going to let you guys go. Have a wonderful Friday. Thanks for being here. Thanks for showing up. Don't forget, just click that little like button before you head on out. All right, I appreciate that. It'll help more people join us next time. All right, have a good weekend. Bye, friends.